Good afternoon. Thank you for joining us for To Reopen or Not to Reopen, How COVID-19 Impacts Nonprofits' Decisions to Return to the Office. This webinar is part of a monthly series that's put on by Venable's nonprofit group, so please check back each month to listen to other topics relevant to your nonprofit's organization. So my name is Jennifer Przinski. I'm here today with my colleagues, Tora Johnson and Robin Burrows. I'm a partner here in our labor and employment group, and I focus my practice on assisting employers with various employment issues that pop up. And I work very closely with several of our nonprofit clients, some of which are in our audience today. And with that, I'd like to give Tora and Robin the opportunity to tell you a little bit about themselves. So Tora?
Hi, yes, thank you very much, Jen, and thanks for everybody on the line today. And I am a partner in our health and employee benefits group. I'm really happy to be presenting with my colleagues and friends today. And I will say that we've been at this work from home for quite some time now, but apologies in advance if you hear any barking, children, spouses wandering into the taping of today's presentation. But thank you for joining us today. Robin?
Hi, my name is Robin Burrows. I am an associate in our labor and employment practice group. Like Jen, I work with a diverse array of clients, including a lot of the nonprofit folks who may be on the line today. And I focus on employment litigation, counseling, and labor relations.
Thanks so much, Robin. Really appreciate that. Thanks, Tora. As you know, both of my colleagues said, we are so glad to have the opportunity to speak with you this afternoon about whether or not to reopen your nonprofit during this really crazy time of COVID-19. And we also want to bring to your attention, issues that you need to take into account when you're making such a decision. And today, we're definitely going to get to your questions. We feel free to go ahead and submit them, but we're going to save those for the end. So, and we look forward to answering those. So today, we want to speak to you not only about the legal considerations that should be taken into account when making an office reopening decision, but we also really want to provide you with a very clear and practical process on how to make that decision. So for those of you who are in the audience that might have already said, yes, we are definitely reopening, we're also going to be discussing COVID-19 related issues such as policies and procedures that you're going to want to make sure that you consider implementing so you can reduce the risk to your organization as well as keep your employees safe. So our goal for today is to provide you with a step-by-step process for determining whether the office reopening is the right choice for your nonprofit. And so as we discuss each of these steps, we're going to focus on several related issues. So we'll address federal, state, and local reopening guidance. As you're aware, there is a significant amount of guidance out there for employers, including nonprofits, on how to reopen their businesses. We're going to talk today about how to identify the guidance that's applicable to your business and then how it should be applied to your particular organization in the event you make the decision to go ahead and reopen. We also want to go through and bring to your attention some of the potential costs that are associated with a reopening. Not only are there costs associated with purchasing equipment your nonprofit may be required to purchase as part of the reopening, but there's also going to be administrative costs that go into actually implementing and overseeing COVID-19 policies and procedures that your nonprofit will want to have in place. And to help you get a better sense of those administrative costs, we're going to discuss specifically the types of policies and procedures that we recommend that you have in place. And those procedures are going to include, and ones that we're going to discuss in greater detail, is going to be how to address employee concerns about coming back to the workspace, as well as how to collect and manage employee data related to maybe underlying medical conditions and the like. And finally, we want to address the potential liability that may come from reopening your office. And so this portion of the discussion is going to include not only those typical employee types of claims that you might come to mind immediately, but we also want to bring to your attention those more novel types of claims that we are seeing arise as a direct result of the pandemic. So because employers are tasked with trying to process this tremendous amount of information that's out there relating to a reopening, and that information is constantly changing and evolving, we thought it would be really helpful to provide a 5-step kind of common sense approach to making your reopening decision. So step 1, assess your current operations. So you want to take a look at your current operations operating in this probably remote environment and ask yourself, is there an actual need to reopen your office? And if so, what are those reasons? And then after you identify the reasons, figure out, okay, what are going to be the benefits that are actually derived from that reopening? Step 2, you're going to want to determine the guidance and the regulations that are applicable to your nonprofit. This is going to include federal guidance and law, of course, as well as state and local government orders and guidance. Then you're going to need to understand what specific measures your nonprofit is going to need to take in order to comply with that applicable guidance and orders. Third, you're going to want to assess your financial and administrative burdens. So after you determine those compliance measures that are going to be required for your reopening, you can assess the financial and administrative burdens associated with those compliance measures. So that's going to likely include the equipment and services costs, as well as any time and resources that are going to need to be dedicated to drafting those policies and procedures I mentioned earlier, and then the time and the resources that it's going to take to making sure that policies and procedures are followed. Fourth, you also want to take into account potential liability. You'll want to consider COVID-related claims employees can bring against your organization in the event of reopening. And while there's always potential liability with running a nonprofit, we want to bring to your attention some particular areas of liability we've seen arise in this COVID-19 context. And fifth, and finally, you'll want to weigh the benefits of the reopening against the financial and administrative burdens and potential liability and figure out, do those benefits that you have from a reopening outweigh those burdens and liability? So let's move on to step 1, assessing your current operations. So like I said in the last slide, first is you want to ask yourself, do we really need to open the physical office, right? And if the answer is yes, what are the reasons that you need to reopen? As part of your analysis, you'll also want to take a look at your reopening reasons and see, are there really areas of concern there that you can actually take steps to eliminate at this time? So these answers are going to be specific to each organization. But we've listed here a few reasons that we've heard often for why a nonprofit feels the need to reopen. The first reason that we probably hear the most is our employees are not as productive in a remote environment as they are when they are working out of our office. Now, for those of you who generally don't permit telework, right, in the non-pandemic world, moving to this remote environment likely presented a lot of challenges for your organization. So now that it appears that none of us are going to get back to the workplace without restrictions anytime soon, it's really a good time to determine, how do you establish an appropriate framework for managing your employees in a remote environment? And so more specifically, have you implemented a telework policy that's specific to the pandemic situation? Or have you had employees sign a telework arrangement that sets forth clear rules about your teleworking environment? And so the rules can address and can include expectations about work hours, participation in conferences and video conferences, employees' obligation to respond to emails and phone calls in a timely manner, and making sure that they're using leave policies when they're ill or when they have to care for dependents in the home. There's also the possibility of thinking, you could have employees actually fill out a daily log so you can keep track of what they're doing on a regular basis. So once those policies or, telework agreements are in place, the employees are on clear notice of your expectations, and if they don't meet your expectations, you can take appropriate corrective action, and this in turn will make them more productive. One thing I do want to note about telework agreements before I move on is if you do decide to use a telework agreement, I'd recommend having all employees sign the telework agreement rather than just one or two problematic employees. When we treat employees differently, sometimes it can lead to claims of discrimination. And quite frankly, as a best practice, it really is a great idea for all employees to sign those agreements so all employees are on notice what your expectations are. And now I'm going to turn it over to Tora to talk about some of the other concerns that we hear about the need to reopen.
And the next one is low employee morale. It's really important during this time to keep employees connected. It was really a very sudden and abrupt change to remote work for many of us, and can be leading to individuals feeling a bit isolated. And then there's this blur between work and home, and for many of us, juggling the demands of work with little or no child care in school, and aging parents or others in the family that require additional support and attention during this time. So what we see are employers reminding their employees of the benefits that are available to them, being the EAP, maybe some additional enhanced counseling services, and then very much a move to telehealth services, and then often cases free telehealth services, not just for COVID related, but for garden variety, medical and mental health attention. And then we see employers are leveraging technology like never before with video conferences and instant messaging features. So that helps foster a community amongst employees, although we are largely remote. And managers instituting weekly, if not daily, morning meetings just to check in with folks, both on a substantive level, right? What work is on people's desks and what are they doing, but also how are they doing, and trying to foster that sense of community and water cooler, although we're all physically quite disparate at the moment. So I do think that considering how the remote workforce is handling and the employee morale issue is one thing that does need to be in the calculus. And when you talk about the third point is the inefficiency of operations. And Jen, I'm happy to speak to this, or are you or Robin taking this point?
I'd be glad for you to go ahead and talk about it, Tora.
Sure. Okay. And then, as I had mentioned, right, we do see employers leveraging technology like never before. So the video conferences and the instant messaging, and that is all wonderful and good, although as part of leveraging that technology constantly, employers should be thinking about privacy and security with leveraging that new technology. And, certain video conferencing service providers have been very much in the news about their security infrastructure. And so it's really partnering with your IT, either in-house capability or vendors in that space to help you manage and look at these alternatives and making sure that they are being deployed in a secure manner. And with that, I think we're moving on to step 2.
Thanks, Tora. So step two, it is determining the measures that are required for your reopening. And quite frankly, I think this is one of the most overwhelming steps to take on. You need to look at all the laws and the regulations and guidance that are going to be applicable to the reopening. And then you got to figure out, how am I going to comply with them, right? It's just not an easy task. It's challenging not only because there's a great deal of information out there, but there's also this kind of lack of consistency among the guidance that's applicable potentially to your organization. So we're not going to attempt to address all the potential sources of guidance. We just want to draw your attention to some places to look and some of the more important guidance. And remember, though, kind of in the back of your mind, even if you pull the guidance and you go to the website on a particular day, remember that that guidance seems to be constantly changing. So part of this reopening should have somebody in place that's kind of looking at that guidance on an ongoing basis to make sure your policies and procedures and what you're doing in the office is compliant with that applicable guidance. One thing I do want to note before we talk about the two types of areas, the federal and the state and local level, the laws, some of the laws and regulations come with real penalties. And what I mean by that is the regulation or the order will say, if you violate this, it means this criminal penalty, or sometimes it's a monetary penalty. So, but there's also this other guidance out there, which we call kind of soft guidance, meaning it's suggestions. And yes, certainly in a lawsuit, could it be used as evidence against you to say that your compliance measures weren't appropriate or the measures you were taking to keep your workplace safe weren't appropriate? Yes. But if you don't comply, there's not necessarily a direct consequence or penalty for not following the guidance. So when you're looking at this guidance, you'll want to definitely see, what level. Is it a soft guidance? Are there actual penalties associated with violating the order or the guidance? So on a federal level, I'm going to talk a little bit about that. As most of you probably are already aware, the most primary federal law that's applicable to a reopening is going to be the General Duty Clause of the Occupational Safety and Health Act. That's OSHA. And it basically says employers need to maintain a workplace that's free of hazards that are likely to cause death or serious harm. So, of course, that would include COVID-19. So you just need to make sure to comply, you're taking affirmative steps to make sure employees are not exposed to the hazard to the best you can. Violations of the General Duties Clause under OSHA actually do come with monetary penalties there. Then there's that second level of kind of guidance that I had mentioned. The most comprehensive guidance is from the Centers for Disease Control and Prevention. I'm sure all of you have been on it. It is being constantly updated, so keep that in the back of your mind. There are several very, very helpful sites on the CDC, pages on the CDC website. There's FAQs for reopening your business. It talks about how to handle suspected or confirmed cases of COVID in the workplace. It talks about when employees can come back to work. So spend a lot of time on that CDC website. We are going to discuss that guidance in a little further detail on into the presentation, but just know that that really is one of your primary sources. And OSHA, federal OSHA, also has kind of soft guidance on reopening the workplace. I would say it's probably more in parallel, but not nearly as comprehensive as the CDC guidance. So I'm going to turn it over to Robin now to talk about the more specific state and local governmental orders and guidance that's out there for you.
Great, thanks. So as Jennifer was saying, we're not going to enumerate today every set of state and local guidance. There are as many of those as there are states and localities. And unfortunately, they are sometimes inconsistent. So you may see information that is sent out from the federal level that in some ways contradicts or seems to contradict information that is given to you at the state or local level, which is part of why it's so important for you to look for your specific state and local guidance. That could be, if you're in a state, the state's executive orders. It could be a county level order. It could even get down to a city level order, depending on where you are and sort of what has been populated for your area. Those executive orders definitely coming out from the governor's level. The federal government has given a lot of control to the states in the COVID pandemic to create their own orders and to direct how reopening or closing of the government will go. So that's your first place to look, is at the state level, is my state even open? What phase of reopening are we in? And those phases are not necessarily consistent across the states. So phase 1 in one state might mean something totally different than phase 1 in another state. You'll have to look specifically to your state and figure out what phase are you in and what does that phase mean for your nonprofit. The same with localities. Even if your state is open or in a particular phase, your city or county may have decided to keep things closed a little longer. So you'll need to look at each of those levels of guidance to be sure that you're complying with the most restrictive set of guidelines that are applicable to you. The State Department of Health often has additional information. So while you may have seen some things from the governor at executive order level, the State Department of Health may have more specific information that would be helpful to follow. And if you're not subject to federal OSHA, you might have a state OSHA requirement. So if you have a state-specific OSHA, for example, Virginia's OSHA, VOSH, you may need to follow those regulations, which may be different than the ones that are issued at the federal level. So for example, if you have a nonprofit headquartered in Arlington, Virginia, you'll need to comply with you'll need to take a look at the federal guidance. You'll also need to look at the Virginia governor's orders. There have been several, and these do change pretty frequently. So as Jennifer was saying, have somebody in your office, if you're going to be reopening, in charge of following these orders and making sure you're keeping up with their continued changes. So you would look at those governor's executive orders. You would look to the Virginia Department of Health, who has published a number of specific reopening guidance for employers and for employee screening especially. You also want to make sure that as you're looking for this guidance that you're looking at guidance that is both general and applicable to all businesses and employers and specific. Some of the states and localities have issued different guidance. For example, if you're a concert hall versus a restaurant versus an office, you may have different guidance for each of those. So you want to make sure that you're looking both for those general orders, what phase are we in, as well as the specific orders. Okay, I'm a concert hall. Is there a different capacity requirement for us? Or if I just have an office, is there a certain percentage of people who are permitted in the office? All of that will be specific to the type of nonprofit that you are and what your business does. And then for our hypothetical nonprofit in Arlington, you'll also have to look, as I mentioned, at the Virginia OSHA regulations. Virginia is an interesting example because they've actually come out fairly recently on July 27th with some specific OSHA guidance that is far more specific and mandatory than a lot of the other guidance we've seen so far. So whereas Jennifer was saying the federal OSHA guidance kind of takes a step back and is not as specific as a lot of the information that you would have from the CDC, the Virginia's new guidance makes mandatory a lot of the recommendations of the CDC and the recommendations that federal OSHA made, and it imposes some additional obligations. For example, the Virginia guidance requires you to conduct a hazard assessment for each job task that employees may be doing. It has additional training requirements. You have to train your employees on how to operate in this COVID environment. You have to draft an infectious disease preparedness response plan. And it's fairly comprehensive. So definitely if you're in Virginia, something you would want to look for. And if you're not, you would want to look and see if there exists similar either suggestions or mandatory guidance for your state and area. The Virginia guidance is one of the ones that we've seen so far with some actual punitive measures. So if you do not follow Virginia's Osha guidance, your first penalty could be as high as a $13,000 fine. So it is definitely something they're taking seriously and something that you'll want to look at and make sure that you're complying with if you are in Virginia. Other states and localities have had similar specific guidance. New York, for example, requires a written safety plan that is quite specific. California requires an aerosol transmissible disease exposure plan. So each state and locality is going to have their own requirements. They're not all quite the same. You might expect, though, that there are some commonalities. And these are things that you probably are not going to be surprised about at this point in the pandemic. So almost every state or local guidance suggests physical distancing, social distancing, keeping employees at least 6 feet apart, wearing a face mask. Staggering schedules is very commonly suggested as a piece of reopening guidance. So you may have some employees who are changing their schedule to come in earlier than usual or start later than usual, maybe working on different days in the office to keep the capacity of your office place down and allow for more of that physical distancing. There's also the suggestion to space out break periods so that not everyone is trying to heat up their lunch in the microwave at the same time, creating a very long queue of people 6 feet apart, things like that. Screening employees, either having them do a self-assessment or doing an on-site screening is very commonly suggested. We'll talk a bit more about that later, but we want to make sure that employees don't have fevers, that if they know that they've tested COVID positive, that's something that they're reporting. Encouraging sick employees to stay home and keeping records of the information that you do have. We want to clean and disinfect the workplace often, and what often means is going to depend on your state or locality. Some have logs that you have to fill out requiring cleaning every hour or every periodic interval, especially on high-touch surfaces, things where people might use it often. You want to make sure your employees have a place to actually follow through with some of these hygiene practices, so hand washing, and that you're actually making sure employees are complying. Things as simple as, do you have enough soap and paper towels for employees to be washing their hands as often as suggested? You'll need to train your employees on following these procedures and have a plan in place if an employee enters the workplace with COVID or has symptoms of COVID. And we'll talk a little bit more about those as we move on. I will turn it over to Jennifer for step 3.
Great. Thanks so much, Robin. So as you're processing all of that information and thinking, oh my goodness, how are we going to comply with all those requirements? In relation to that, step 3 is you need to take a look and assess the financial administrative burdens that's going to go along with trying to comply with that. So there's a couple types of burdens and costs that are going to go into your assessment here. The first is those direct financial costs. And so when you're trying to assess those direct financial costs, I think that a great place to start would just be looking at your physical office space, right? And determine if you're going to need to reconfigure your office to adhere to those social distancing guidelines or those other types of requirements. Now, I know for those nonprofits who are fortunate enough and have office spaces that, you've got single offices with doors for all employees, this configuration issue is not going to be really relevant to you. However, in recent years, we've seen a trend toward open workspaces. So for those of you with open workspaces, you need to look to see, can you reconfigure the desks so that all employees are 6 feet apart? Are you going to have to purchase some type of equipment, such as plexiglass barriers or other screening things to put in between the workstations to minimize the spread? If it's a particularly difficult reconfiguration, are you going to have to hire a consultant to help you with that? You'll also want to look at the cost of supplies that you may be required under applicable guidance to provide to your employees. And of course, as Robin had mentioned, it could be face mask, it could be hand sanitizer stations that you have to put throughout. But there's also those cleaning supplies that some guidance requires you to provide. And then also, in addition to those kind of guidance-related costs, you also want to think about whether you're going to be providing particular subsidies to your employees. So, we've had employers think about, oh, okay, well, should I provide some type of parking subsidy for my employees so my employees can drive to work rather than taking public transportation? Another cost may be, are you going to provide some type of child care subsidy now that a large majority of schools are going to be, 100% online, and it's going to be challenging for, some of your employees to manage that? And are you going to provide, subsidies to kind of offset that? You'll also want to look at, the cost of cleaning services. I'm sure that that's already in your overhead, but you also need to take into account whether you need to increase the frequency of your cleaning services and what the cost is going to be associated with that, as well as how much is it going to cost to do the, quote, special disinfecting of the workplace if there has been a confirmed COVID occurrence in your workplace. And now I'm going to turn it over to Tora to speak about the costs related to daily screening and measures and testing.
Great, thank you. Yes, we see employers that are opening their offices again, implementing some form of screening and testing, as Robin mentioned just a minute ago, for employees returning to the workplace. And I should note that the ADA ordinarily would prohibit screening and testing. It generally prohibits an employer from making disability-related inquiries and requiring medical examinations. However, there is an important exception for when an employer has a reasonable belief based on objective evidence that an employee's ability to perform essential job functions will be impaired by a medical condition, or, in this case, what comes into play, an employee will pose a direct threat due to a medical condition. And based on guidance from the CDC and public health authorities, COVID-19 meets that direct threat standard. These authorities have acknowledged the community spread of COVID-19 and issued those restrictions on public gatherings. And the EOC has come out and said that these actions and this common knowledge now support the finding of significant risk of substantial harm of having an employee with COVID or symptoms of it present in the workplace. So employers are doing all kinds of things, from testing to temperature checks to questionnaires. And so when you talk about testing, and requiring testing before somebody returns to work, you need to think through several things. The ADA is specific that you cannot use the antibody test, that it has to be a viral test. So looking for somebody with an active case, not the antibodies for having had the case of COVID. And you also want to think through if you're doing testing or you're doing temperature checks before somebody enters the building, you're likely using a third party to conduct the testing and or temperature checks. Those third parties may be subject to HIPAA, the law that protects medical information, and to be able to get the results of the test and of the temperatures, that third party, if they are subject to HIPAA, will need to get an authorization from your employee to release the results to you. But that's only if that testing company, which likely is subject to HIPAA, right? Or if you hire a third party to do temperature checks, is subject to HIPAA. Once the information comes over to the employer that is not HIPAA protected information, you have that role you have that information in your role as an employer. It's just like the notes that you get to support an FMLA leave. But we also see employers not necessarily going that far and requiring a test or temperature checks, but asking employees to fill out questionnaires based on CDC guidance. So those are questionnaires asking employees to say, do they have fever or chills, a cough, shortness of breath, fatigue, muscle or body aches, headaches, new loss of taste or smell, sore throat, congestion or runny nose, nausea or vomiting or diarrhea. And those are the symptoms that the CDC has on their website, and oftentimes we see it couched as not otherwise explainable, as a way to screen out and catch the COVID-related, not the common allergy case. And some employers are having it be self-executing, where the employee just ticks through it, and then if they come up with, okay, I have none of those symptoms, I'm good to go, the information doesn't get fed back to the employer. In other cases, we see the employer collecting the questionnaire, and in that case, going to HR. It should be a very centralized process as to where the information goes. And that's a paper-based questionnaire. We see others using apps to do this, and there's been a whole cottage industry that's grown up during COVID with these apps. And if you're an employer vetting the apps, you want to take a very close look at the services agreement you have with the app developer, and you want to look at the privacy policy. You want to know how is the information your employees are entering is being used, and how's it being secured. For instance, I would really think hard if the app was going to de-identify the information and then have a right to that de-identified information, and what is being collected and how long, whether you're using an app or you actually are collecting questionnaires or you're collecting temperature readings, how long are you holding on to that information? Don't hold on to it longer than you need. It is medical records subject to the ADA and should be kept confidential and secure. But I do really want to emphasize here that the information in your role as an employer is not PHI. It is not subject to HIPAA. It is sensitive information, potentially. And again, under the ADA, you need to keep it confidential and secure, but it is not PHI subject to HIPAA. We field that question quite often, so I wanted to make sure we really answered that piece. And once you have the policy, if you decide you are going to require some testing or questionnaire, you should really have that captured in a written policy. And then that policy should also talk about when folks who have symptoms can return safely to the office. And here, we really suggest piggybacking on the CDC guidance. Again, they have very detailed guidance for individuals who think or know they had COVID and had symptoms, and the general rule of thumb is that the person needs to stay out at least 10 days since the symptoms first appeared and have gone 24 hours with no fever without taking any fever-reducing medication, and their symptoms have improved. And then there's an alternative if their healthcare provider has said that if they can get 2 negative tests in a row, they might be able to return sooner. And then there's a whole different test for folks that have tested positive but have had no symptoms. And again, that should be captured in your policy. And really, the CDC is the best place to look for it. But you are talking about infrastructure costs here, right? You're talking about, first of all, thinking through, okay, what's the best solution for the nonprofit? And if you are engaging a app provider, what's the cost of that? And then it's documenting how you're going to go forward in a policy. So it really does need to be part of the financial considerations in deciding to reopen and how to reopen. And with that, back to additional administrative compliance measures. Jen?
Yeah, great. Thanks so much, Tora. For those of you today who are listening to this webinar for CLE, the CLE code is Nonprofits 2020. So now I'm going to go ahead and continue on with the administrative compliance measures that I had mentioned earlier. So again, we were just talking about these kind of direct financial costs that are going to come as a result of a reopening, but you'll also need to look at kind of the administrative cost as well. And I look at them as being really twofold. It's really going to be what is the time and the effort that are going to go into researching, right? Because you have all this information to kind of sort through, sift through, and then somebody's going to have to take that information, analyze it, and turn it into policies and procedures that are going to keep your employees safe and minimize liability. And then on that note, those types of policies are really twofold. There's going to be employee policies that are distributed to all employees, but then as a practical matter, it likely makes sense to have some more internal management policies that only go to a subset of the management employees that talk about how the policies that are distributed to all employees are actually going to be administered. So that's kind of the first type of the administrative cost. But then there's the second, which is not only are you going to have to determine the time and effort that's going to go into, putting all these policies together, but then there's the time and the cost associated with making sure that management and employees actually adhere to these policies. So as I mentioned, there's the employee policies. There's going to be policies that you're going to want to distribute to all employees. That's going to be based on the guidance and the kind of those areas that Robin was discussing earlier. So right here we've listed some of those employee policies that we recommend implementing, kind of based on guidance as well as best practices. So reporting, you've got one for reporting for capacity limitations, right? It's going to depend on your state and local guidance. Your nonprofit may be subject to certain capacity limitations for your workplace, so you need to make sure you've got employee procedures in place. Is it, let us know if you're coming into the office, are you going to issue work schedules? Are you going to have them report and do staggered shifts? But again, you need to have very clear instructions to your employees so you don't have your entire workforce showing up to the office on one day. Tora discussed in the last slide there, having that procedure for COVID reporting, but it's also going to be important to reduce that again to a written policy. So employees need to understand when they need to report, to whom they need to report. And as kind of a side note, it's really fine to have the employee report COVID or COVID symptoms to their supervisor, but as we're going to discuss in the next slide, it's really important to have, an internal management policy so that the supervisors know actually what to do with the information once they receive it. And so the right folks in your organization can know to make sure the appropriate measures are being taken. And Tora also talked about the screening measures and the testing, but again, once you make those really important decisions, as far as compliance and what's going to be the right thing to keep your employees safe, you've got to reduce it to writing. You got to make sure the employees understand. You should definitely have some type of policy about disinfecting the workspace, the frequency of which may be based on, applicable guidance, or maybe you just tell employees as a matter of best practice, clean at the beginning and the end of your workday. Social distancing and types of meetings, that's going to be super important. Again, I know that it's in all the guidance and probably everybody knows about social distancing and 6 feet apart, but again, you really want to reduce this to a written policy to show that you're really taking these issues very seriously. Also, if you're going to be providing personal protective equipment, you may want to have a policy on, how to use it. That could be, or how to use maybe the touchless tools that some organizations are providing. You also want to have a policy about common use areas and equipment. Take a look at your workspace again and think about, are your conference rooms large enough to adhere to those social distancing requirements? You might need to close the room, but if you don't, Figure out what policy you're going to have in place to make sure that social distancing guidelines are being adhered to, as well as the cleaning requirements. You also want to have procedures in place for those frequently touched surfaces that equipment employees are going to be using, like copiers. What procedures you're going to have in place for cleaning after use, and then also definitely clear guidance on areas that employees normally congregate in, such as kitchens or break rooms. Again, you want to make sure social distancing guidelines are being adhered to, as well as any capacity limitations that may apply. The travel I have listed here too is kind of a big issue for a lot of nonprofits, and I know folks are really eager to get back to business travel, but I can't stress the importance of looking in real time at the travel restrictions based on your location. You want to look at the restrictions not only in the location where your office is, but also the location that your employee is going to, right? I'm going to give DC as an example. Some of you may know as recently as in the past week or so, the mayor issued guidance in which it says if anybody comes from a high-risk area into DC and is not performing essential business as defined in the order, that employee or that individual has to self-quarantine for 14 days before they can go out. So really that's going to eliminate the effectiveness of the business travel. So definitely take a look at that and see what orders are applicable to the travel areas that are at issue. Because other states, as you know, New York and Massachusetts have other travel orders in place. I just saw on the news today that there's checkpoints in New York with regard to travel. So I think at a minimum, if you're contemplating having and permitting business travel, if you're permitting business travel at all, at a minimum, what you'll want to do is have your employees get permission prior to engaging in the travel and get approval. So somebody within the organization who understands how to analyze the travel orders and the like can make sure that you're adhering to all the requirements. Finally, you also want to have a visitor policy. I know several employers are just simply saying no visitors to the workplace. It eliminates a lot of the risk. But if you do have visitors to the workplace, think about, are you going to have, what screening measures are you going to have in place? Are you going to have them sign waivers and the like? And then finally, I'm going to talk a little bit about it more in the next slide, but you'll also want to talk on, I'll also talk a little bit about how to train the employees on these policies. So again, these are the policies that we recommend distributing to all employees. And now Tora and Robin are going to talk a little bit about some of the internal management policies. So I'll turn it over to Tora now.
Great, thank you. Starting with the capacity limitation compliance, and Jen has already touched on this, it is important that management have a procedure in place to track who's reporting into the office. It can be by getting advanced approval for work days in the office, or it could be using a staggered work schedule, but it will be important to have a process in place to handle and make sure that you're complying with the limited capacity. And then a very tricky question tends to be, what happens if we have an employee that reports COVID-19 positivity? What do we do with that data? What are our responsibilities? Well, I mean, the first step, right, is that individual should either be sent home or told not to report to the office that day and to seek appropriate medical care. Then you have that data. That data is very sensitive data. Again, medical record under the ADA, confidential and secure, not PHI, not part of your covered entity, not subject to HIPAA, but sensitive. And then it's important to handle and to start with contact tracing. Who was that individual in contact with? And having conversations with those employees and potentially impacted third parties. And I say potentially in that the third parties are really limited in the workspace right now, as Jen has already touched on. But notifying employees that came in contact with the individual who has tested positive, there is no need at this point to identify the individual with the positive test result. It's not necessary, and we counsel against it to preserve that individual's confidentiality. And the ADA guidance would allow an employer to report the positive test in the individual to public health authorities. Generally speaking, the required reporters under state law are the healthcare providers and the labs that are doing the testing. It's generally not the employer outside of a healthcare setting. So generally we would counsel against it. I will say that I believe New York has that soft guidance that Jen mentioned earlier that would require reporting to public health authorities by employers. But generally speaking, really counsel confidentiality here. It is important to do that contact tracing. That can be done without disclosing the individual's name. And then it's disinfecting the workplace, which we've spoken about a little bit already. The CDC has said in most cases an employer doesn't need to shut down the facility to do that cleaning, and really has issued very much common sense guidelines about how to do the cleaning. So shut off the area where the person who tested positive was and clean that area, and generally wait about 24 hours before you do that to make sure that the respiratory droplets are no longer in that area before employees go in and do that cleaning. But it's very much common sense. Again, the resource for this is the CDC's website. And, it doesn't just stop with the employee, and Robin will talk a little bit about the employee and the household member health issues.
Thanks,
so with that,
Laura.
Robin?
Yeah, so as you're making these plans to come back into the office, you definitely have to refresh your knowledge of the Americans with Disabilities Act. There's probably somebody who has previously been handling requests for accommodations under the ADA in your office, and if you are going to be reopening in the time of COVID, you're certainly going to get a lot more. As you probably know, the ADA has an interactive process requirement. So if an employee comes to you and says, I have a health condition that puts me at higher risk for COVID, we'll talk just a little more about those in a minute, but if an employee has such a health condition and comes to you asking for a reasonable accommodation or for some kind of accommodation, you are required under the ADA to engage in the interactive process and see if there's a reasonable accommodation that will allow that employee to do their job effectively. In pre-COVID times, you probably knew that this could be telework, it could be technology that might help them in the workplace. Right now, we are seeing a lot of requests for potential telework as a reasonable accommodation under the ADA. Another potential accommodation you may consider is unpaid leave. If an employee doesn't have any leave now and is unable to come into the office for a reason that you determine is a disability, unpaid leave might be an accommodation that you want to consider. And the CDC list of individuals with underlying medical conditions that are at increased risk for COVID is quite long, and many of them can potentially be disabilities that qualify under the ADA. If you haven't looked at the guidance recently, it was actually just updated in mid-July, so you may be due for a refresher. The CDC now lists two different categories of people who have the possibility of being more at risk for COVID. So they list as are at increased risk individuals with cancer, chronic kidney disease, COPD, an immunocompromised state or a weakened immune system from solid organ transplant, obesity, serious heart conditions, sickle cell disease, and type 2 diabetes. You can find that information on the CDC's website. Those are conditions that the CDC believes are at increased risk of severe illness from COVID. There's also a second category where the CDC thinks they might be at an increased risk for COVID. And these include some things that you might not, either might not have thought of or might not initially consider a disability, like pregnancy, smoking, asthma, somebody's HIV status, even if their HIV is well controlled with medication, type 1 diabetes. These might be at a risk for severe illness categories. Are things that may or may not be disabilities, depending on the employee and how they present that to you. With all of these categories, we suggest engaging in the interactive process, regardless of whether you think it is a disability in the strictest kind of normal sense. So if your employee has cancer, almost certainly a disability, engage in the interactive process, see if there's a way that you can accommodate them. If your employee is a smoker, engage in the interactive process, see if there's something that you can accommodate if they approach you about wanting a reasonable accommodation. With smoking in particular, you may also want to look at your state-by-state guidance, because different states actually have different protections and anti-discrimination laws when it comes to smoking. So smoking may actually be a protected state under your state and local guidance. Older adults have also been identified as being at potential increased risk for COVID. And of course, this impacts, it touches on the ADEA, the Age Discrimination in Employment Act. We see this come up really in two ways for employers. The first is employers who, with the best of intentions, want to tell all their older workers to stay home and not come into the office. And the guidance is pretty clear that is not something you should be doing right now. So you cannot single out your workers over 65, for example, and tell them, do not come into the office, basically, you're too old. The same is really true with these other increased risk categories as well. You know, if somebody has a heart condition and they approach you for a reasonable accommodation, do engage in the interactive process with them. If you know they have a heart condition and they do not approach you for a reasonable accommodation and they want to come into the office, at this point the guidance suggests that you should let them. I also want to touch briefly, since we're running out of time, on the various leave accommodations that or leave issues that you may face as your employees return to the office. As you may know, the federal government passed the Federal Families First Coronavirus Response Act, the FFCRA, which provides some additional leave to employees that is federally reimbursable. If you've been teleworking up until now, your employees may not have felt the need to take advantage of that leave. If you now are going to ask your employees to come into the office, there's a possibility that they will want to use that leave instead of coming in. And this is something that you may need to think about for staffing issues. You may need to backfill those spots for this federally protected leave. You may be granting more leave requests than you previously were. And you may have more telework requests. If you've been teleworking relatively successfully up until now, employees might expect that they will have an option to telework in the future. You'll want to have somebody internally who is knowledgeable about the policies that Jen was mentioning you should be creating and the laws around this area, who can moderate whether or not these requests, the ADA accommodation requests, these telework requests, whether these sorts of requests will be granted. With that, I will turn it over to Jen to talk more about financial and administrative burdens.
Yes, thanks. And we are really running out of time, so I'm going to make this really brief. Do take the time to train your employees on the new policies that you reduced to writing. And why is it? Employees get handbooks all the time and they don't read the policies. Make sure they understand them and these new policies. So invest in a training session so they can, so you can clear up any confusion, make sure everybody's clear and keep your workplace safe. And again, I just want to say one more time, please make sure somebody's there to oversee the administration of these policies and procedures. Make sure the policies are being applied equally to all employees during this really difficult time. The last thing that you need as an employee saying to you, I was treated differently because of another employee, and it was because of a protected category, right? So with that, I'm going to turn it back to Robin, who's going to quickly run through step 4, which is assessing potential liability.
Great. So we have talked so far about a number of laws. I'm not going to go over again sort of OSHA and ADA because we are almost out of time and we've talked about those a little bit. But there is potential liability both from administrative enforcement actions or from employee complaints or lawsuits that could arise out of those OSHA and ADA claims. So if you are refusing reasonable accommodation requests, for example, an employee may be able to file a lawsuit against you based on that. Workers' compensation, we haven't talked a lot about yet. Some states have created a presumption that workers who get COVID are presumed to have a workplace injury that will be compensable through workers' compensation. Other states have not. Workers' compensation a lot of times will take care of those claims that might otherwise have been lawsuits against your nonprofit. If you are in a state that does not have this presumption, it's possible that there could be some more individual suits related to the workplace injuries related to COVID. Some employers have been asking us recently if they can get rid of some of this liability with employee waivers. Can my employee sign a form that says, I accept there's risk to COVID and I won't sue my employer if I'm coming to the office? Generally, those are disfavored. So we usually do not recommend having employees sign waivers as a condition of employment, or even if the employee wants to sign such a waiver, we usually recommend against it. They're unlikely to reduce a lot of liability. Again, that's state by state. There's different laws in different states about how those are handled, but they don't reduce liability very much, and they make the employer look a bit heavy-handed. So we usually prefer to talk with employees about perhaps an acknowledgement, if that's something that you would want to have your employees do, acknowledging the different protocols that you've put in place, the policies that Jennifer was talking about earlier that hopefully at that point you've written, and acknowledging that they're going to abide by those things like social distancing, mask wearing, hand washing. Ultimately, hopefully a lot of those claims might be handled by workers' compensation if you do have issues related to your employees getting COVID in the workplace. But the acknowledgement of those protocols can go a long way, both with your employees and kind of how you message and roll out these changes to them. And also to reduce the liability that comes when inevitably employees just don't feel heard. Those waivers don't do a lot for employees, kind of from an employee relations perspective. From the lawsuit side, as I mentioned, workers' comp sometimes takes care of these sorts of claims, but these are new and unusual times. So we are seeing new and unusual lawsuits. We've seen some for kind of negligence or gross negligence, where the idea is basically you didn't provide notice of the risk of COVID, you didn't take adequate safety precautions, things like that, basically that you didn't follow the best available guidance. And as a result of that, you could be subject to a lawsuit. That's why even though some of this guidance that we've discussed is suggested, even if it is not mandatory and doesn't have a kind of a harsh punishment that comes with it, it's definitely worth looking at because your employees may still claim that you weren't following that suggested guidance, and for that reason you were negligent. We've also seen recently some wrongful death claims brought by families of employees or third parties who came onto the premises and contracted the virus either while working or while being on the employer's premises, basically saying the employer didn't take those reasonable safety precautions that we've talked about, things that even include sterilization and social distancing. We've also seen some kind of on a public nuisance theory that by failing to follow health laws, the employer has created or contributed to the growth of COVID, and that is a public nuisance. You know, all of these claims are still in their infancy because COVID is so new, and this is a situation that we really haven't seen before. We anticipate there will probably be more that come out, more creative causes of action. They won't necessarily be successful. Some of these, you know, the employer might be able to defend against them, but they're not it's not risk-free, this reopening process. Even if you're able to successfully defend against one of these lawsuits, you still spent a lot of money defending against it. That's why we suggest there's a lot of benefit in being upfront with your employees, communicating with them, having them feel heard in the reopening process, taking their thoughts and concerns into account. All of those things really help make the nonprofit look like they're making a good faith effort to reopen with the best available information. And that can go a long way with employees who are scared and frustrated about the situation and how things might be changing in the future. Jen, I'll turn it back to you for step 5.
Okay, great. Thanks, Robin. So step 5, it's pretty straightforward. You just need to determine whether the benefits of reopening outweigh the burdens and potential liabilities. You know, you've gained an understanding now what your office is going to look like under the applicable restrictions, right? And you've assessed the financial and administrative costs and burdens that is going to come with reopening your office, as well as potential liability. And then, you know, you just figure, do those benefits outweigh the cost? If the answer is yes, you know, if you make the decision after you draft your policies and procedures, or do some of the writing, or do the training, then you do your reopening, right? Making sure those policies and procedures are followed. If the answer is no, you know, continue working in your remote environment. Try to take some of the suggestions we made at the outset, maybe by having telework policies or telework agreements to make your employees, you know, continue to be productive, and, you know, take some of the suggestions that Tora made about maintaining efficiency in your operations. And then, you know, in maybe a couple of months, reassess where you are and go through this 5-step process again. And so, just to briefly summarize, this last slide here just has the 5 steps again, so you can take it with you and walk through it. So I hope today's presentation has been helpful to you. Unfortunately, we have been overly ambitious and have run out of time for questions. I did see a great deal of questions come in. So happy to have you here and participate and be interested. We will try to follow up. If we're not able to, we have all of our contact information is there at the beginning of the presentation. And so again, thank you so much for joining us. We appreciate it, and stay safe and have a wonderful day.